treaty violations, and legal claim of right to redress. I, Daniel Gomez, am a direct descendant of an enrolled member of the Sioux Nation of Indians, Santee Sioux tribe. I have suffered harm and injury at the hands of a group of hostile actors under color of law, and I now seek redress and relief under constitutional protections and treaty obligations. Pursuant to the First Amendment of the United States Constitution and Article 1, second paragraph of the 1868 Fort Laramie Treaty, I invoke my right to bring forth this grievance for redress. The treaty explicitly states, if bad men among the white or among other people subject to the authority of the United States shall commit any wrong upon the person or property of the Indians, the United States will, upon proof made to the agent and forwarded to the Commissioner of Indian Affairs at Washington City, proceed at once to cause the offender to be arrested and punished according to the laws of the United States, and also reimburse the injured person for the loss sustained. This binding treaty language imposes both a legal and moral obligation upon the United States government to provide immediate remedy and justice for any wrongs committed against Indian persons by individuals under its jurisdiction. My injuries are directly attributable to such treaty violations and the unlawful acts of state and local officials acting in derogation of federal supremacy and indigenous sovereignty. You may refer to my federal complaint filed in the United States District Court for the District of South Dakota, Southern Division, Gomez versus Elk Point, Union County, et al. Case number 424-CV-04216, Lawrence L. Pearsall. Claims include but are not limited to deprivation of rights under code of law, unlawful arrest and kidnapping, violations of 4th, 6th, and 14th Amendments, treaty violations, and indigenous civil rights, as well as constitutional violations. Government officials, public servants are not immune from suit, as stated in Rabin versus Rowan Memorial Hospital Incorporated. Immunity fosters neglect and breeds irresponsibility, while liability promotes care and caution, which caution and care is owed by the government to the people. Government actors, whether judicial officers, public officials, or law enforcement agents, are not entitled to immunity when acting beyond the scope of their authority or in violation of clearly established constitutional treaty rights. C. Owen versus the City of Independence. Brady versus Roosevelt Steamship Company. Land versus Bauer. The courts have also consistently held that when a state proceeds against a private individual in a judicial forum, it is well settled that the city, state, county, or municipality waives any immunity to counterclaims, cross-claims, and complaints by direct or collateral means regarding the matters involved. Luckenbach versus Thickley. Furthermore, when enforcing mere statutes, judges of all courts do not act judicially and thus are not protected by judicial immunity. This declaration stands as both a formal notice of treaty violation and a reaffirmation of constitutional violations against unlawful state actions. The government has a duty not only to prosecute the offender under federal law, but also to provide full restitution for the harm inflicted under the protections granted to indigenous people. Notice of void judgment due to lack of jurisdiction, judicial misconduct. I did utilize AI to scan this, and it offered to Case number 63C080000237AO. And criminal case number 63C080000286AO. Related civil case, habeas corpus 09-389. South Dakota Supreme Court numbers 30100 and 30364. Comes now, I, Daniel Gomez, pro se, and respectfully submits this notice of void judgment challenging the legal validity of all proceedings, judgments, and orders in the above captions matters. Defendant asserts that the judgment is void ab initio due to multiple constitutional and procedural violations, including lack of jurisdiction, judicial and prosecutorial misconduct, violation of oath of office, and deprivation of rights under color of law. Lack of jurisdiction. The court lacked lawful jurisdiction over the subject matter and person in this case. A judgment rendered without jurisdiction is null and void and has no legal force or effect. See Ex parte Roland 104 U.S. 604. Specifically, defendant asserts that on or about June 7th, 2008, Deputy Palmer and North Sioux City Police Officer Nicholas Davis conspired with Melissa Larson, a clerk of court, to fabricate a backdated arrest warrant predated to February 2nd, 2006, in violation of SDCL 23A-2-2. Said warrant was not issued by a duly authorized magistrate judge, lacked sworn testimony or affidavit establishing probable cause, and was not legally endorsed in accordance with SDCL 23A-2-10. I was arrested on June 7, 2008 without lawful warrant or probable cause, an act amounting to unlawful seizure and kidnapping under color of law in violation of 18 U.S. Code sections 241, 242, and the 4th and 14th Amendments to the U.S. Constitution. Further, I was continuously in custody in Iowa from October 12, 2005 through December of 2006, negating any factual basis for a warrant dated February 2nd, 2006. These actions constitute an orchestrated deprivation of liberty by state actors, rendering all subsequent judicial proceedings unlawful and void. Judicial misconduct. The presiding judicial officers, including but not limited to Justice Stephen R. Jensen, engaged in conduct exceeding lawful discretion by knowingly proceeding on the basis of a fabricated arrest warrant, issuing bond conditions while being fully aware that no lawful order for return to custody existed, failing to disclose or address material defects in the charging process. Judicial misconduct violates the principle of impartiality and renders decisions void. See Toomey v. Ohio, 273 U.S. 510. Prosecutorial misconduct. I allege prosecutorial misconduct by Michael J. McGill, Philip Peterson, John Slattery, and Jerry Miller, all of whom failed in their ethical and legal obligations to uphold due process and prosecute only upon lawful grounds, knowingly pursuing charges based on false reports and a forged arrest warrant, participating in the malicious prosecution and unlawful imprisonment of myself for multiple years under inmate IDs 50853 and subsequently 52426, violation of oath of office. Officers of the court, including Justice Jensen and Senator Art Roush, violated their constitutional oath by enabling or failing to prevent the deprivation of constitutional rights and the use of fabricated legal instruments. Biased and prejudicial rulings in related Supreme Court proceedings numbers 30100 and 30364, in which Justice Jensen failed to recuse despite a clear conflict of interest. Inadmissibility of evidence, fruit of the poisonous tree. All statements, confessions, and evidence obtained as a result of the unlawful arrest and fabricated warrant are inadmissible under the exclusionary rule. See Wong Soon versus United States. Additionally, any proceedings flowing from this unlawful arrest, including subsequent charges and confessions, must be vacated as they derive from an unconstitutional seizure. Supporting precedent. State versus Hayen, 2008. The South Dakota Supreme Court in State versus Hayen invalidated a detention where the officer lacked reasonable articulable suspicion after a minor traffic stop. Similarly here, Officer Davis had no legal basis to detain or arrest Defendant Gomez, rendering all subsequent searches and statements constitutionally invalid. Relief requested. Declare all judgments, convictions, and warrants void ab initio due to lack of jurisdiction and constitutional violations. Order immediate dismissal and expungement of all related charges and proceedings. Cease all enforcement or execution of any orders, warrants, or judgments in the above captioned matters. Issue summons and arrest warrants for all public officials and officers involved in the